Good afternoon, my fellow citizens. Happy Constitution Day. And I'm going to give you a lecture on the Constitution. All you people who don't know how to critically think and sit and listen and understand something from a critical standpoint, you can leave now. Because few are the citizens that really can sit down and think about the Constitution of their country. Few. James Madison wrote, "All societies are made up of warring factions. The rich against the poor, religion against religion, race against race, small republic. A small republic, like a state, too often falls prey to one of these factions." I'm going to start again. James Madison wrote, "All societies are made up of warring factions. The rich against the poor, religion against religion, race against race. A small republic, like a state, too often falls prey to one of these factions. The result? Lawlessness and oppression. It is only in a large republic with many different-minded people that no one faction can gain control. In such a republic, the liberties of all the people are naturally safeguarded. Such a republic, if it were dedicated to justice and protected by truth and of the spirit of the people, would, I believe, last through the ages. But first, it must exist." My fellow Americans, it was this kind of a republic birthed into existence by our founding fathers in the Constitution of the United States in 1787. This milestone in human liberty, under law, brought into being for the first time in human history a government where the rights of man are acknowledged to be derived not from the state, but from the Creator himself. We must always remember the chief duty of government is to protect the God-made rights of God-made man. Life, liberty, and the pursuit of happiness. Wise old Ben Franklin was asked by a Philadelphia woman today, 235 years ago, "What have you given us in this Constitution, Dr. Franklin? A monarchy or a republic?" And Benjamin Franklin responded, "A republic, madam, if you can keep it." This, my fellow countrymen, has been the charge of the American Republic for each generation, to keep the American Republic in operation enduring freedom for each generation of Americans. God grant we keep and keep well the American Republic for ourselves and our posterity. The ideal of Alexander Hamilton, delegate to the Constitutional Convention and supporter of the Constitution, is thus spoken in these words: "The sacred rights of mankind are written as with a sunbeam in the whole volume of human nature by the hand of divinity itself." This noble and grand ideal, that the human rights of all persons were written upon their very being as created by God before any act of government, is the foundational ideal of human dignity, and this is grounded upon the faith our fathers had in the revelation of Holy Scripture. In the image of God, He created them. Male and female, He created them. That's the basis of human dignity. That's the basis of human equality. Our governmental concept of representation is based upon the English Parliament, consisting of the House of Lords and of the House of Commons. The English formed this representative body in the 1640s during their own revolution against Charles I. Liberty is the core principle of American constitutionalism. Liberty is the capacity to think and act upon one's own volition without external force. It is to act on conscience, not upon compulsion, yet with enough law to provide the order that makes liberty possible. In point of fact, another statement of Alexander Hamilton: liberty must be reconciled with order. And this drives home the point, for without order there is no liberty, only license. Both liberty and order facilitate a free society under law. Without order, liberty devolves into license. True liberty is not doing whatever one wants, but to do what one ought to do by a free act of the will in accord with one's conscience. This trains one in the habit of doing good, which is virtue. Our founding fathers, their vision of America was that of a republic of virtue. The people are the ultimate source of legitimate power. This power is exercised through the elected representatives who themselves are from among the people. The Constitution begins with the words, "We the people." In this, the authors state, it is the people who have a government, not a government that has a people. Before the Constitution of 1787, the 13 colonies each had their own state constitutions granting many rights, chief of which was religious liberty. And many historians and many Americans contend that that is the cornerstone of our being, religious liberty. And I agree. The most famous of which was William Penn's Charter of Religious Liberty in 1701 in Pennsylvania. It was to commemorate the act 50 years later by casting a bell which would become known as the Liberty Bell. The state constitutions were the start of our representative republic within the context of constitutionalism. The Continental Congress was the representative body of all the colonies, but before that, it was the Virginia House of Burgesses in Williamsburg, Virginia. This body had its origins in the so-called Great Charter of 1618, issued by the Virginia Company of London. It convened on July 30th, 1619. How about that for a 1619 project? Like the British House of Commons, the House of Burgesses granted supplies and enacted laws, and the governors and the council enjoyed the right of revision and veto, as did the kings in the House of Lords in England. Our system of government derives from our heritage of English law and liberty. The council also sat as a Supreme Court to review the county courts. Each state had a constitution and a governor, either elected by the people or appointed by the king. That governor would be known as a royal governor. Thomas Hutchinson was the one royal governor appointed over Massachusetts. And poor old Thomas Hutchinson, he had to bear the brunt of the anger of the Bostonians in the early days of the Revolution. During the War for Independence, the Continental Congress was the main governing body, and then the state governors. But there was no central authority for the colonies. They were united, but not under a central government. The Continental Congress passed the Articles of Confederation on November 15, 1777, in the midst of our War for Independence, to unify the colonies and gave power to raise revenue. The American colonists were opposed to a strong central government with taxing power, as this was one of their reasons for revolting against King George III. From the very beginning of our history, the full power of centralized government was an anathema to liberty-loving individuals. The full power of centralized government was the very notion the fathers were opposed to. It was left to each state to be the local power. It took nearly 4 years for all 13 states to ratify the Articles of Confederation, during which time the War for Independence was being fought. On March 1st, 1781, the Articles of Confederation were ratified, becoming the first document to unite all the colonies together under a common form of government. This was in force from 1781 to 1787, when it was replaced by the Constitution of the United States. The Constitution was being written while the Articles of Confederation were governing the colonies, and we went from the Continental Congress to the Confederation Congress. There are 13 articles which comprise the Articles of Confederation, but only 7 articles comprise the Constitution. So you see, we went from a bigger to a smaller government. The Confederation Congress passed an important document known as the Northwest Ordinance of 1787, which laid out the geography of 5 future states: Michigan, Wisconsin, Illinois, Indiana, and Ohio. In fact, I'm standing in my backyard, which back 235 years ago today was part of the Northwest Territory and was probably a howling wilderness. Slavery was not allowed in the Northwest Territory, and it gave private property to people and established a public school system. The Constitutional Convention was the arena and the stage for national heroes such as George Washington of Virginia, Benjamin Franklin of Pennsylvania, and for theorists of government, such as James Madison and James Wilson, both of whom from Virginia, and Alexander Hamilton from New York, and elder statesmen, such as the aforementioned Benjamin Franklin and John Dickinson of Delaware, and Roger Sherman of Connecticut. Some of these men also helped Thomas Jefferson write the Declaration of Independence 11 years before, and it was the ideals of the Declaration of Independence upon which were the foundation upon which these men would write the Constitution. There were advocates for local interests, William Patterson of New Jersey and Luther Martin of Maryland. These were the spokesmen for states' rights, and such other men as William Blair of Virginia and Jacob Broome of Virginia sought to find consensus and compromise. Indeed, the Constitution of the United States is a product of compromise, particularly between two big interests, the states and the nation. Also, the great balance between liberty and authority. Another essential compromise, and probably the one on which the Constitution is based, is the proper balance of representation of large states and small states. In the legislative branch of the government, the legislative powers vested in a Congress of the United States consisting of a Senate and a House of Representatives. George Washington presided over the Constitutional Convention, as it was called. Well, we call it the Constitutional Convention, but back in the day it was either known as the Federal Convention or the Grand Convention. Washington spoke very little. Only one time did he admonish the delegates for not keeping secure their papers when he found a misplaced letter on the floor. The Federal Convention met from May 25th to September 17th, 1787. It was during this time when, for the first time in the history of government, federalism as a form of government was instituted. This is the experiment of a central government and the several states in cooperation with each other. The problem or challenge of the relationship between the central government and the several states. The Secretary of the Convention was one William Jackson of Georgia. The Constitution is a blueprint for a federal form of representative government on two intersecting planes, the federal, the central government, and the state governments. In each of the states, they have their own state constitutions. And the state constitutions of all of the 13 original colonies that became the states pre-existed well before the Constitution of 1787. And people often say, well, why doesn't the Constitution say freedom of religion or mention God in the preamble? Well, most of the state constitutions already mention God and their faith in God. So the founders believed that it was already an accomplished and stated fact in the state constitutions. Because you have to remember that for well over 150 years, for a century and a half, during the development of the colonies along the eastern seaboard of North America, you had planted the seeds of the idea of representative government that guaranteed religious freedom and guaranteed representative government in the states well before the federal government was ever formed. The concept inscribed in Article 4 of the Constitution states that each state would be provided with a republican form of government based upon the same structure as the federal government. So this idea of a republican form of government first began in each of the states, but then to become United States, the Constitution gave us a federal government over all of the states. We have a system of government in which interdependence and constructive conflict combine to make progress, and also to make sure that no one man or set of men gain too much power. It also embodied a proper representation of the people in both large and small states, larger states such as New York and smaller states such as Delaware and Rhode Island. The latter state, Rhode Island, did not send delegates to the Philadelphia Convention, and thus attending delegates referred to it as Rogue Island. Edmund Randolph of Virginia proposed the Virginia Plan, outlining a national government with supreme legislative, executive, and judicial branches. And that would be the basis of the federal form of government. William Paterson of New Jersey rejoined with his New Jersey Plan, a plan based on the Articles of Confederation giving Congress more power. The battle was over representation in the Congress of large states and small states. The small states would be equally represented in Congress, and the large states would be based on population. It turned out that all states, large or small, would have 2 senators, and based upon the population in the various districts of the states, would determine the total amount of representatives for each state in the House of Representatives. For instance, as an example with the English, the House of Lords and the House of Commons make up the Parliament of England, back then and even now. We took that as an example, although we didn't make a parliament, we made a Congress. But we took an example from the House of Lords, and that kind of like became our Senate. We modeled our Senate after the House of Lords, the upper house of Congress. And then our House of Representatives could be like a House of Commons, the lower house of the Congress. Because early on, the senators were selected by a select group of people in the state legislatures. And so they were kind of higher up, farther away from the people. But the representatives, more like the House of Commons, because they were chosen by the people directly, and they were closer to the people in their individual state districts. The great compromise from the delegate of Connecticut was that there would be a Congress consisting of 2 houses, a Senate and a House of Representatives, House of Lords, House of Commons. In the Senate, regardless of size, a state would have 2 senators, and in the House of Representatives, each state would have representation based upon population, with each state divided within itself amongst congressional districts, each district represented by a representative, member of Congress. The plan of the election of the President of the United States is found in Article 2, Section 1 of the Constitution. And the President of the United States represents all the people of the United States. But he is to be indirect, but it's an interesting way the Founding Fathers determined how he would be elected. He would represent the entire United States, all the people of the United States, but would be indirectly elected by them. And that's known as the Electoral College, which used to throw me for a loop and probably still throws a lot of people for a loop. And some people want to oppose it. Some people want to abolish it. I used to, but now I'm standing firmly for it. Well, the President of the United States, who represents all the people of the United States, was to be indirectly chosen upon the popular vote, but ultimately chosen by the Electoral College, a group of persons representing the candidate and voting for the candidate who won the election, who won the electoral vote of a state by winning the popular vote of the state. The electors do not have to vote accordingly, but they usually do. The Electoral College vote for president was also an attempt to keep the balance between the large and small states, in this instance referring to their population. The Founding Fathers wanted representation to be fair and advantageous for all the states in the legislative branch and also in the executive branch. This was the reason for the Electoral College. Each would have an electoral vote equal to the total number of its senators and representatives. Each state would. So Illinois, I think now, by virtue of the most recent census, we've got 27 electoral votes. 2 senators added to the amount of representatives we have gives us a total of 27 electoral votes. And we have 27 Democratic electors and 27 Republican electors. And depending on which candidate for president receives the popular vote of the state, those electors then go to the state legislature in Springfield and give the candidate the entire electoral vote of the state. And, well, it's usually a Democrat because Illinois is controlled, unfortunately, fortunately or unfortunately, however you want to look at it, by the Democratic Party. Although there are many, many, many Republican counties in Illinois. But anyhow, that's how Illinois has been voting for president for the past several elections. And it's different for each state, depending on their status. Well, I mean, the popular vote in, say, a red state like Indiana is more for the Republican Party. The popular vote for, say, a blue state like Illinois is more for the Democratic Party. And that's just a matter of demographics and demography. But the Electoral College process acts in its own way independent of that, and the electors have to vote for whoever is elected with whoever gets the popular vote of the state. And they usually act accordingly. Like, for instance, if Illinois which probably will, go blue in 2024, you can be darn sure that all the Democratic electors will go to Springfield and vote for that candidate, that Democratic presidential candidate. And I'm not a betting man, but I certainly wouldn't bet that they would turn and give the votes to the Republican candidate. They could, but chances are they won't. So, anyway, now that I've confused everybody well enough, let's continue. Based on the popular vote of each state, the candidate receiving the majority of the popular vote would receive the total of the state's electoral votes, until one of the two candidates, sometimes three candidates, receives the necessary majority of the electoral vote, and that would determine which candidate wins the presidency. Our fathers did not anticipate political parties, but once they came into prominence, each state would choose by their legislature a slate of electors of each party. In elections, when parties were represented beginning in 1800, the candidate with the majority of popular votes in a state would receive the majority of electoral votes cast by these electors of his political party. The electors don't have to cast for their candidates, but by custom they usually do, as I aforementioned. If neither candidate wins a majority of the Electoral College vote, then the election is decided in the House of Representatives. And this happened in 1800 and in 1824. Gouverneur Morris of Pennsylvania wrote out in full the Constitution we see on parchment today, in the National Archives, and in the historical reproductions we see. Our Constitution is written, whereas the English Constitution is a series of documents and handed-down traditions. The Constitution of the United States is the government of the American people. It is our federal form of government, and in Article 4, there is an ingenious plan of a Republican form of government for each of the states, modeled on the federal government. This is what makes each of the states sovereign, and yet within the federal system. A time-honored constitutional debate has long revolved around the question, did the federal government create the states, or did the states create the federal government? There are patriotic Americans on both sides of the question. The nature of the Union and the relationship between the Union and the states has always been a point around which revolves much constitutional debate. In a sense, the Constitutional Convention is always in session, as Americans continue to debate its meaning, as Woodrow Wilson once commented, referring to the Supreme Court as a constitutional convention in continuous session. As they interpret its meaning, I am a firm believer that the states created the federal government. That's the side of the argument I stand, upon which I stand. Because there was no federal government over the states until the people of the states voluntarily formed a union of states under a federal form of government. The union of the states gives us the federal government. Yet power would not be arbitrarily wielded over the states. They were to be sovereign with their own republican form of government, with the constitutional guarantee written in the Article of Amendment, the Bill of Rights, the 10th Amendment, the powers not delegated to the United States, nor prohibited by it to the states, are reserved to the states respectively or to the people. Then we had a great family dispute called the Civil War between 1861 and 1865, and that could be looked upon as a violent constitutional debate over states' rights versus federal power. The union of the states under the Constitution was restored. At the same time, sovereignty of the states was also maintained. Ronald Reagan contended the states created the federal government, and I agree with him. In his 1981 inaugural address, he declared, "All of us need to be reminded the federal government did not create the states. The states created the federal government." This, along with the 10th Amendment in the Bill of Rights, was in line with Reagan's policy to return to the states their rights and duties, which had heretofore been exercised by a federal government grown too big. Reagan was interested not in abolishing the federal government, but in reducing its size and overreach. He had claimed that Franklin Roosevelt had said that he would do just this if elected in 1932. Well, he was elected, but according to Reagan, Roosevelt either forgot or reneged on his promise. And Reagan believed it was his turn, it was his chance to finally help Franklin Roosevelt fulfill his promise of bringing the states, of giving the states back to the states the power that they enjoyed under the Constitution. I have always pointed to our Illinois state motto for guidance on this issue: state sovereignty, national union. In the debates on the Constitution, the Federalists were in favor of the Constitution, and the Anti-Federalists were opposed to the Constitution. And they felt Anti-Federalists were more for states' power, for the states, sovereignty of the states, power of the states' rights. Federalists, they believed in that, but they also did not want us to forget that under the Constitution, the federal government received top billing. But really, though, when you think of it, it's not the federal government, it's not the states, it's not the counties or the localities that are over the other, although they are. It's the Constitution of the United States that is over all of these entities of government. It is not the federal government is the supreme law of the land, not the state governments, the supreme law of the land or of the states, not the local or county governments, the supreme law of the land, but the Constitution of the United States is the supreme law of the land. And all laws passed under it are also the supreme law of the land. And so this debate, Federalist, Anti-Federalist, centered around the concern Americans have about the nature of governmental power. A debate that never stops. It began really from the start of our experiment in self-government. It concerned the danger of a strong central government with taxing powers and a lack of a guaranteed Bill of Rights, a cherished English tradition of law and liberty. It was King Charles I of England who signed the Petition of Right in the 1640s, which was one of the models for the American Bill of Rights. Alexander Hamilton was one of the founders in favor of the Constitution, believing that a federal form of government could at once preserve order and maintain liberty. As he maintained, liberty must be reconciled with order. Without order, there is license, not liberty. The former is the notion that one can do whatever he wants. The latter notion is one does what one ought, is that one does what one ought, freely, on conscience, not compulsively out of fear of the governmental authority. And that, I think, is the essential difference between a republican form of government and a dictatorship. In a dictatorship, governmental power is arbitrary. In a republic, governmental power is regulated by checks and balances, dispersal of power, and frequent elections. This is the better way, and our founding fathers gave it to us. The best form of government conceived by the genius of man. James Madison was a firm believer in the federal Constitution as well. In fact, he is known as the father of the Constitution. And yet, he was also a major force behind the adoption of the Bill of Rights. If men were angels, no government would be necessary, he wrote. Government is needed as a disciplinarian check on behavior of citizens and leaders alike. The essence of government is power, and power, lodged as it must be in human hands, will ever be liable to abuse. James Madison. Our founders believed in God, but they also knew human nature, the good and the bad of it. Hence they knew, those founding fathers, that the people's sovereignty depended upon frequent checks on the power of their government. Abraham Lincoln, who, in his fight to keep the states under the Constitution of 1787, was often criticized as expanding the power of the federal government. And he faced this with this question: must a government of necessity be too weak to maintain? Must a government of necessity be too strong for the liberties of its own people, or too weak to maintain its own existence? This question is always before us as we live under a government such as ours, conceived as it is with its freedom of choice, its breadth of opportunity, its range of alternatives. It controls its powers as it governs with its powers. The Constitution itself is a document of government which lists its powers, but also lists its limits, and so itself is a check upon the power of the very government it constitutes. The Federalists were in favor of the judicial branch as the defense of liberty. Jefferson later feared that the judicial branch could become a despotic branch of the government, as he thought the Supreme Court would have too much power in deciding what laws are constitutional and what not. The judicial branch, the courts of our land, in their ideal, are open to all as the interpreters of the Constitution. Their wheels of justice grind for all people, all causes, and they look to every avenue of justice, every concern of the law, and they temper their reasonings and their judgments through mercy and reason for all. This is the ideal for which the American system of jurisprudence always strives. It's not easy, and there are always people less than satisfied. Then again, justice is impartial, and it deals reward as well as punishment. In Article 6 of the Constitution is declared the supreme law of the land, as we mentioned earlier. All officers of the government, civil and military, swear an oath to be loyal to it and to live by it and to defend it against all enemies, foreign and domestic. But no religious test is ever required of a person to hold any office of public trust. Anti-Federalists were opposed to this, but Federalists extolled this ban on religious tests as a defense of religious liberty. Anti-Federalists in New England denounced the slavery clauses, but Southern Federalists supported them. It is interesting to note, and very positive in my view, that nowhere in the Constitution do we find the word slave or slavery, except in the 13th Amendment when it was declared unconstitutional and abolished from this land. Our fathers wanted slavery to be placed on the road to ultimate extinction, and it was. It was also Lincoln's viewpoint, as he would later express himself on the issue in his debates with Douglas. Lincoln knew our fathers intended all men to be free, to ensure that the sacred rights of mankind first given by God were written on parchment. And so it was that the first Congress of the United States proposed a Bill of Rights championed by James Madison of Virginia. The Bill of Rights were proposed on June 8, 1789, and ratified by the states on December 15, 1791. The Constitution explains how amendments are proposed and ratified in Articles 5 and 7 of the Constitution. The Convention of the States, or the state legislatures, propose amendments as historical exigencies arise through time. Congress can also propose amendments. The Bill of Rights was proposed by the Congress and not by the states. The Congress then presented them to the states for ratification, as according to Article 5. After a period of debate over the ratification of the Constitution, on June 21, 1788, New Hampshire's ratifying convention adopted the Constitution by a vote of 89 to 79, and thus became the 9th state to ratify the Constitution, making it the government of the United States, and finally replacing the old Articles of Confederation. The first state to ratify the Constitution was Delaware on December 7, 1787. Delaware, the first state to ratify. And each of the former colonies became states in the Union as they ratified the Constitution of the United States. And this process was effected pursuant to Article 7, Section 1. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. At the time the Constitution was signed by the 56 delegates on September 17, 1787, George Washington offered hope to the skeptical delegates and said there is a door open to constitutional change which time may prove necessary. There are those doors open to constitutional change to help the government of the United States under the Constitution to be one of perpetuity for each generation of Americans. In a sense, the Constitution is an enduring freedom. Okay, so here are the three ways to amend the Constitution. First, by constitutional amendments. As per Article 5 of the Constitution, in which the amending process is described, the subsequent amendments to the Constitution can be categorized in these groups: the Bill of Rights, the fundamental principles of liberty and self-government. These list our basic political and religious rights: religion, speech, assembly, the press, and the right to petition the government for a redress of grievances. The right to state defense and personal defense, protection against quartering military personnel in private homes, except under special circumstances, to be secure in personal items and in the home against unreasonable search and seizure, only warrants issued on causes with specific items mentioned for search and seizure, the rights of citizens faced with criminal charges, defense in legal matters, right of trial by jury, assistance in legal matters, not to be twice tried for the same offense after acquittal, the right against self-incrimination, due process of law, trial by jury, rights of the accused, time, place, and manner of trial, no excessive bail or cruel or unusual punishment, rights retained by the people are protected as are listed rights. The states and the people have reserved powers unto themselves. This is the Bill of Rights of 1791. And the Civil War amendments of 1865 through 1870 extended these rights to the newly freed slaves. The right to vote, the right to be a citizen of your country and of your state, the right to the equal protection and due process of the law. Do you think you'd find these in any other country in the world? Well, perhaps in England, because this is where we got our whole idea of constitutional law from, our English forebears. Second, the advance of democracy is a core component of the constitutional system. Popular election of U.S. senators, and voting rights for more and more of our fellow citizens. Right, remember, as previously mentioned, it was the state legislatures that were called upon to vote for the United States senators. But of course, each of these state legislatures would go to their constituents in their districts and find out who was the popular candidate. And more often than not, they would vote for that candidate that was popular amongst the people. But it wouldn't be the people's vote, it would be the vote of the representatives, the legislators in the state capitol. And because the Democrats had a majority in the state capitol in Springfield in 1858, they voted for Stephen Douglas to be the senator, to re-elect him to the Senate instead of electing Abraham Lincoln. Well, it's a good thing we didn't have Senator Abraham Lincoln, because then we wouldn't have had President Abraham Lincoln 2 years later, unless he decided to still run for president as Senator Lincoln, which that could have happened too, but of course it didn't. It didn't happen that way. All right, the third way, we're still with the amending process. The third group of amendments concerning the Electoral College, presidential terms of office, and presidential limitation and disability, that's Amendment 25. These repair defects of the original Constitution and respond to problems not considered by its original draftsman. So, the amending process is the first method of constitutional change. The second method of constitutional change, the second door to constitutional change, is through the interpretation of the Constitution by our third branch of government, the judiciary. From the Supreme Court to the lower courts on both the federal and state level. Because as we have a federal government and state governments, we also have a federal court system and a state court system. Some milestones of American law have been from Supreme Court rulings, but some have been ignoble, such as Dred Scott versus Sandford, where the federal government had no power to limit slavery in the territories, and this helped spur on the Civil War. In the first Supreme Court case in 1789 of Marbury versus Madison, it was determined, among other things, that the court had a role in reviewing acts of Congress. This is known as judicial review. The flyover wasn't supposed to come until after I finished. Not yet 100 years after the Civil War, in 1954, in Brown versus Board of Education, racial segregation in public schools was struck down. This ruling overturned the Plessy versus Ferguson 1896 decision, which made separate but equal the law of the land. But this law was overturned by the 13th and 14th Amendments. By that time, in 1896, the 13th and 14th Amendments were passed already. But the southern states didn't care. So they ruled against equal protection of the laws, but they ruled in favor of separate but equal in 1896. But then it took almost 80 years later, in 1954, for the Supreme Court to overturn that decision and strike down separate but equal, and reaffirm the position of equal protection of the law and equal opportunity under the law. The 13th and 14th Amendments, they had already been passed in 1865 and 1868. And it was those amendments that overturned the Dred Scott decision. As recently as last year, the Supreme Court overturned the 40-plus year Roe versus Wade decision on abortion and returned the issue back to the states. The third door open to constitutional change is through custom and usage. Custom and usage are the philosophical and historical issues that arise around the Constitution as the country evolves, spurring debate on constitutional issues expressed in legislation and in court decisions, and manifested in the various needs and concerns of Americans. All these reflect the pomp and circumstance of government, and yet in all of this, the Constitution remains the solid rock upon which our government of, by, and for the people stands. And under God, and the law shall continue to stand. Because without this form of government, no American can be free. And if our America remains under God and the Constitution, we are free, and by divine providence shall ever remain so, as long as the American people and our constitutional republic stand for democracy and freedom. Thank you very much.